So imagine you're facing some serious criminal charges and your defense attorney gets the case against you dismissed in just a matter of weeks. Well, that's what happened for a couple of my clients in just the last month. I've had 4 cases dismissed, including 2 felony cases and 2 misdemeanor cases. Let's talk about how I got that done. Hey, how's it going? I'm attorney Vincent Hughes, and I practice family law, criminal defense, traffic ticket defense, CPS defense, and personal injury law here in the beautiful state of California. So a lot of times clients come in and they tell me that they're facing these criminal charges and they're extremely old. When that happens, I always tell my clients, let's go ahead and file what's known as a Serna motion. A Serna motion is a pretrial motion that essentially tells the state you've waited too long to prosecute this case, should be dismissed for lack of prosecution and a violation of my client's Sixth Amendment rights. In California, those accused of criminal charges have the right to a speedy trial. What this means is that if you're accused of a misdemeanor, you have the right to have your trial heard within 45 days of your arraignment. In felony cases, you have the right to have your trial heard within 60 days of your arraignment. If the government unreasonably delays in bringing you to trial, the court will likely dismiss the charges against you under a case called Serna. What this means is that a defense attorney, pre-trial, will generally file a Serna motion with the court if there's been some kind of extremely long delay in bringing you to trial in your case. A Serna motion essentially argues that because there's been such a long delay, things have changed, memories have faded. The witnesses may not be easily accessible to bring to trial. Evidence may have been lost. More importantly, the defendant might not even be able to raise his own defense to the case against him. That's how I got 4 cases dismissed in the last month. So in one of the cases I just discussed, our client was never even arrested for the charges that he was facing. The case was extremely old. It was about 6 years old. And our client didn't even know that there was a warrant for his arrest until he applied for a job at a very major company. When he did the background check, they informed him that he had a felony warrant. Our client contacted me, and we later determined that he actually had 2 warrants for 2 old cases. One of the cases he was arrested for, but it was older than the first case that he just learned about from the employer. So essentially speaking, our client was facing 2 separate felony cases, and these cases were both over 6 years old. Well, as a good seasoned attorney, I looked at the case against our client, looked at the discovery, and determined that the government did in fact unreasonably delay in filing formal criminal charges. Furthermore, they delayed in not trying to bring our client to court in order to get to trial. They knew where our client was. He actually had lived in the same home for multiple years. They knew that he was available. He wasn't in custody. He wasn't dead. But in reality, the district attorney's office did nothing to pursue prosecution other than issue a warrant. So I filed some Serna motions, and after an argument, the court determined that there was very little evidence that can be used against our client because the evidence had been purged, that means destroyed, by the law enforcement agency, and all that existed was the police reports. Well, long story short, a couple days before Christmas, our client got a very, very big surprise when 2 felony cases were dismissed and he was able to keep his pristine, perfectly clean criminal record intact. I'm hoping that our client got that job that he tried to get, but all in all, he was extremely happy because those charges were dismissed and we didn't even have to go to trial to do so. In the second set of cases that were dismissed pursuant to Serna motions in the last couple weeks, we had a misdemeanor client. He had 2 separate misdemeanor cases. Both of them were nearly 15 years old. In fact, our client just got out of federal custody. He was in the federal penitentiary for over 10 years. He contacted us because when they were releasing him from the federal prison, they let him know that he had some warrants. So we contacted our office, we went down to the court and determined that he had 2 separate cases that were filed against him back in approximately 2007. What we did is we went into court, we made oral Serna motions this time. We didn't even write written motions, we made them orally to the court, and the court agreed. There was probably no evidence against our client, and so the cases were both dismissed. Our client actually owed about $1,500 in fines and fees to the court from one of those past cases, and because of the length of the delay, as well as the fact that our client had been in federal custody for 10 years, the court actually used that custody credit to just pay off the fines. Again, our client had 2 cases dismissed. So what's the moral of the story? What's the purpose in us even talking about Serna Motions? Well, it's clear. If you're facing serious criminal charges, or even if you're facing not so serious criminal charges, it never hurts to pick up the phone and have a free consultation. That's what our felony client did. He picked up the phone, he gave me a call, and I discussed with him what his options were. He went from having no knowledge that he had anyone looking for him or any pending criminal charges to feeling assured that we were going to do everything we could to fight like hell to get him the best result. We wrote some very detailed motions to the court. Over the prosecution's objection, the court granted those motions, and our client walked away with no felony record. In the case of our misdemeanor client, he had been through the system, he knew about the pending charges, but that didn't matter. Because there was an unreasonable delay, the court still granted the motions and still dismissed the case against him. So never forget, when accused, call Hughes, tell a friend, tell a family member, we're here to help.